All right. This is a government lecture, just kind of a makeup lecture, just kind of a brief overview of what you may have missed in regards to our lecture. Obviously, it was two 50-minute classes, so I will cut out probably a lot of the stories and things. But just kind of give you the facts of the class so you can get the right kind of notes there. And this week we talked about the amendments to the Constitution. Of course, we know that the Constitution originally had 7 articles, and then there were a bunch of amendments, 27 different amendments that have been added to the Constitution since we passed the Constitution. And so Roman numeral number 1 is the Bill of Rights background. And we put for letter A, we said that it is the statement of an individual's citizen's legal privileges which may not be taken away by the government. It's a statement of an individual's citizen's legal privileges which may not be taken away by the government. Of course, that's what our Bill of Rights lists. And of course, we talked about the argument that some people had. Should we have a Bill of Rights if we list certain rights? Does that tend to give the idea that the government gives us our rights? Of course, we don't believe that either. But ultimately, they decided we needed to write a Bill of Rights and list these are individual rights that people have. The government's not allowed to take from them. Letter B, we mentioned 3 documents that gave us the background to the Bill of Rights. And those 3 documents are the Massachusetts Body of Liberties, the English Bill of Rights, and the Virginia Declaration of Rights. And so those 3 documents gave us the background: Massachusetts Body of Liberties, English Bill of Rights, and Virginia Declaration of Rights. And then we mentioned letter C, that Madison proposed 12 different amendments. 10 of those passed and were ratified on December 15th, 1791. And so the Bill of Rights was ratified on December 15th, 1791. Of course, those first 10 amendments being called the Bill of Rights. We did mention that Madison did have one of his other amendments that did not pass at this time, later passed as our 27th Amendment, 1992. The amendment that was proposed by James Madison was picked up by Congress and passed in 1992, dealing with congressional pay. I mentioned this quote, a very important quote. I hope you will get this down. I'm sure you will see it on a quiz or whatever. But it is, for every right, there is a corresponding responsibility. And for every privilege, there is a corresponding duty. For every right, there is a corresponding responsibility. And for every privilege, there is a corresponding duty. Today, we have a lot of people that are clamoring about, we want our rights, we want our rights, we want our rights. But very few people talking about what are the responsibilities that I have as a result of having rights. We talk about privilege, but what is my duty? Every right has a responsibility. Every privilege has a duty with it. We talked about Roman numeral number 2, the Bill of Rights. And we did not get very far in this section, but it's pretty easy outline. Letter A is going to start with the Amendment 1, and we're going to go all the way through the alphabet and deal with the different amendments given in those letters. So, letter A is Amendment number 1. That deals with freedom of religion, freedom of speech, freedom of the press, and right of petition. So there's 4 different categories there: freedom of religion, freedom of speech, freedom of the press, and right of petition. Underneath that, number 1, freedom of religion. And I gave several different points dealing with freedom of religion. Little letter A, Congress shall make no law respecting an establishment of religion. And that is a quote right out of Amendment number 1. And that little quote is called the Establishment Clause. Maybe you've heard people talk about the Establishment Clause in the Constitution. It's right out of Amendment number 1. Congress shall make no law respecting an establishment of religion. What is it saying in part? That the federal government is not allowed to make a national church. They're not allowed to establish any particular religion. By the way, it does not say that they can't help in religion, that they can't help fund Christian activities or things like that. Of course, we know that the early Congress actually put funds out for Christian missionaries to reach the Indians. And so we know that it didn't mean that they couldn't have anything to do with religion. It just simply meant that they couldn't have a national church. Little letter B. This is also a quote out of Amendment Number 1. Congress shall not prohibit the free exercise of religion. Congress shall not prohibit the free exercise of religion. And of course, that part is part of a quote there in Amendment Number 1. And you'll want to write down next to this is called the Free Exercise Clause. Once again, some of these clauses, you'll hear it from time to time. People mention it, and that is the Free Exercise Clause. Little letter C. Please note that the founders wanted to prevent a national religion or a state church. All right? They didn't want to give any denomination preferred status. Now, that was, of course, a debated thing. Not all the founders felt that way. It really was Baptists that gave us this idea of complete freedom of religion. I think of Patrick Henry, a great founding father. His idea was, let's have 4 different denominations as national churches. And Church of England, the Episcopal Church, the Congregational Church, and the Baptist Church. And all 3 of those were fine with it, but the Baptists said, no, we do not want to be part of a national church. We think that the government has no right to tell people what religion they have to be. And so it was Baptists that gave us that freedom of religion. Put down little letter D. The founders wanted to safeguard the freedom of religion and liberty of conscience from the federal government. The founders wanted to safeguard the freedom of religion and liberty of conscience from the federal government. Of course, once again, the founders believed that people had the right to practice their conscience in regards to religion. They didn't feel like the government should be forcing people to go into religion. Of course, early Massachusetts Bay Colony, people were required to go to church. They were required to baptize their infants. It was by law, and they could be punished for not doing that. And the founders came to the idea, mainly through Baptist influence, that government should not be in the business of forcing people into certain religious activities. Put down a little letter E. They wanted the states to deal with the religious establishments. All right. It was really a state thing. In fact, we mentioned in class that really the Constitution does not stop states from having state churches per se. In fact, I listed a few. The Congregational Church was the state church of Connecticut until 1819. It was the state church of New Hampshire until 1819. And it was the state church of Massachusetts until 1833. So it really didn't stop states from having certain denominations as their head denomination. It was just stopping the federal government. And of course, nowadays we don't have any state churches at all. But that was the idea. They wanted states to deal with religion, not the federal government. Please write down letter F. Little letter F. Thomas Jefferson and James Madison made it clear that the Establishment Clause did not mean that all religious influence in public life are prohibited. They wanted to make it clear that the government could participate in helping religion as far as the spread of Christianity. It was just simply meant to not let the federal government prefer one denomination over the other. And that was it. Sometimes people will say separation of church and state found in the Constitution. That terminology is not found in the Constitution. In fact, the only place it's really found is in a letter, a personal letter from Thomas Jefferson to the Danbury Baptist Association, basically telling them, we are putting a wall of separation between the federal government and churches so that the government doesn't involve themselves in the church. And that was really the purpose of it, all right? And of course, we mentioned already that Congress passed a bill for printing Bibles. They also supported missionaries from tax dollars. in order to evangelize the Indians. And so we see that the government was involved in religious activities. That wasn't the problem. It was just making sure that they didn't prefer one religion over the other. All right, put down little letter G. Since 1947, the Supreme Court has interpreted the Establishment Clause to be a wall of separation between church and state, which cannot be breached. Since 1947, the Supreme Court has interpreted the Establishment Clause to be a wall of separation between church and state, which cannot be breached. All right, and so nowadays they say the government can't be involved in religion at all. And we put down little letter H. The court uses the Lemon test to decide Establishment Clause cases. So anything that deals with the Establishment Clause, they use what they call the Lemon test. And I believe it got that name because in the trial, one of the sides was last name Lemon, I believe. But out of that trial came a test that the court tends to use, and it's a threefold usage. First of all, the Lemon test says that laws must have a secular purpose. The second part is that the law's primary effect must be neutral towards religion. And third, the law must not foster excessive entanglement between government and religion. All right, so the law must be secular in purpose, it must be neutral towards religion, and it must not foster entanglement between government and religion. Although the Lemon test is used, we do see that they don't always really use it, and there is no rationale. For instance, our Army has chaplains, our Congress has a chaplain, and yet they say in other instances we can't have religion in our institutions. You think about in some places they say you can't have a manger scene in a government building, and yet they'll let a Jewish menorah be put up there, and yet that is a religious symbol. You think about instances, I cited the Alabama State Supreme Court, Chief Justice Moore had a big monument that was the Ten Commandments, and they ruled that must be removed because of separation of church and state. He refused to have it removed, and they came in forcibly and removed the Ten Commandments. And yet, hanging above the heads of our Chief Justice of our federal Supreme Court is the Ten Commandments. And so there seems to be really, no rhyme or reason for how they judge some of these things. One person said the Lemon test is really a lemon. It doesn't really work very well. Little letter I, the Free Exercise Clause allows the practice of religion, but it limits it to the scope of common decency and law and order. And so what we mean by that is you can't just practice religion without common decency standards and law and order standards. For instance, I can't say I'm going to start the first Aztec church in the United States of America, and of course, in regards to our beliefs, we believe in sacrificing babies. All right, well, obviously that's illegal. You can't commit murder even in the name of religion. And so freedom of religion does not protect you from breaking law and order. We think about certain fundamental Muslim Islam followers who believe that you can fly planes into buildings and kill people that don't believe like you. Well, that kind of religion is not allowed in the United States. It must fall under the laws of common decency standards and law and order. And write down this court case. This was kind of the court case that firmed that up. Reynolds versus the United States. In Reynolds versus the United States, the Mormon Church was taken to court because of their practice of polygamy. And the court ruled that they were not allowed to practice polygamy in the United States because that violated the common standards of decency. And so it was amazing. Of course, for the Mormons, polygamy was part of their salvation. If you read their Doctrine and Covenants book, chapter 132, I think, says that polygamy is kind of a necessary thing for them to go to heaven. And yet, when the Supreme Court did rule that, and they actually were looking at removing kicking the Mormon Church out of the United States, one of their prophets got a vision from God that said that they did not need to practice polygamy anymore. So I guess very convenient for the Mormons in that regard. Nonetheless, Reynolds versus the United States did that. Number 2 underneath of Amendment number 1 is freedom of speech. And please write down a little letter A under that. The founders intended to protect responsible speech. And that's important. You have to have responsible speech. We don't have freedom to just say anything irresponsibly. For instance, I can't go into an airport and yell bomb. I might have freedom of speech, but I'll get arrested for that. That could cause a panic, which could cause people to die. I can't go into a crowded building and yell fire. All right, if there's no fire. It only protects responsible speech. And write down the court case that dealt with that, Chaplansky versus the United States, and that was in 1942. Chaplansky versus New Hampshire. I don't know if I said that right. Chaplansky versus New Hampshire. The court declared that the right to speech did not include lewd, obscene, profane, or libelous expressions that was intended to inflict injury or incite a breach of peace. All right, and so that was a pretty important court case in that it really prohibited obscene and foul language and things like that. And we'll see that later gets reversed. But that was the court case. Put down little letter B. Slander is not allowed. It's not permitted. And of course, the definition you want to know that is slander is false speech. All right, put down little letter C, libel. And the definition for that is false writing. These are forms of non-protected speech. It's true, you can say what you want to say, but if it's slanderous, if it's not true, you can be sued for that, and you can be fined or go to jail for those things. You can publish what you want to publish, but if it's not true, all right, you can be tried for that. Put down little letter D, the laws of treason. Do not allow a citizen to say anything that would harm his country or advocate for its violent overthrow. All right, you're not allowed to give away our nuclear secrets or do anything that would potentially cause harm to our country. You're not allowed to advocate for the violent overthrow of the government. All right, it's not to say you can't say we don't want to we want to vote for this guy and not this guy for president, but we're talking about violent overthrow of the government. You're not allowed to do that. All right. Put down a little letter E and write down this court case. There's actually 3 court cases, but I only had them write down one. Cohen versus California, and put in parentheses there 1971. We'll see actually there's 3 different cases here that kind of changes the law a little bit. Cohen versus California, 1971. Rosenfeld versus New Hampshire, or New Jersey, 1972. And Papish versus Board of Curators, 1973. So 71, 72, 73. The court declared that the most abusive, uncivil, and immoral speech was legally protected. And of course, that changed what basically Chaplansky versus New Hampshire said, which was you can't have lewd, obscene, or profane speech. That kind of reversed that and said that kind of speech is allowed. All right. And in 1989 and 1990, the court actually ruled that a person could burn the United States flag because they had freedom of speech. And so we see quite a bit of change happening in the area of speech in regards to that. All right. Number 3 underneath Amendment number 1 is freedom of the press. And put down the little letter A underneath that. Freedom of the press guarantees the liberty to publish everything without prior restraint. All right. And what that basically means is the federal government's not allowed to censor what you publish. Once again, you can publish whatever you want to publish, but you can pay the price for publishing things that aren't true. Now, there are maybe a few exceptions. Obviously, if you work for the government and you are, aware of state secrets, they will censor and make sure that you're not giving away state secrets. But for the most part, there is no censoring of publications. It can be printed before being checked out. All right, little letter B, any publisher can face legal consequences for what he publishes. All right, so you better be careful about what you publish. Make sure it's true. Little letter C, 1873. Please write down this law, the Comstock Law. And this was a pretty important one. All right, this is kind of a pushback to some of the court cases that we saw up earlier. In 1973, Congress passed the Comstock Law, which prohibited the distribution of pornographic literature through the mail. And so that was a pretty important law. You can't send that stuff through the mail. In 1957, write down this court case, Roth versus the U.S. The court overturned a lower court case that found the publication of obscene and unmailable because it might cause immoral thoughts. And so the court kind of upheld the Comstock Law there. A lower court tried to reverse it, and a higher court upheld the Comstock Law, basically. But what they did in this case, and this is important, they defined obscenity as this: utterly without redeeming social importance. And that was what Roth versus the U.S. said, that obscene means utterly without redeeming social importance. The problem with that definition is anybody can kind of say, well, I find you might not consider that socially important, but I consider that socially important. And of course, today we've seen a lot of these things done as a result, because people say, well, I think that pornographic literature is art, it's science, and they're able to try to use that kind of stuff. And then write down this court case, Miller versus California, 1973. The court rejected the 1957 court case, the idea of without any redeeming social value, and basically said that pornography and anything else could be mailed through the mail. And also, that was where we got the idea of sex education in public schools. And so, what a shame, 1973, pretty bad year there for us as Christians. Put down number 4 underneath the First Amendment, freedom of assembly and redress of grievances. And underneath this, we put letter A. This gives citizens the right to peaceably assemble and protest. All right, and once again, emphasis on peaceably. All right, you're not allowed to go and burn down buildings in the midst of your protest. All right, shoot guns in the air and those kind of things. All right, you're not allowed to do that, but you are allowed to protest. You are allowed to assemble, and they legally cannot stop that. Now, put down little letter B. The court has regulated itself in 3 areas: time, place, and manner. And basically what that means is they've said, you have the right to protest, you have the right to petition, but we do have the right to ask, as the government, time, place, and manner, all right? When is this protest going to happen? Where is it going to happen? And, what is the protest about? And once again, that's not really to stop people from protesting. It's just to ensure the safety of everybody that's involved. We want to make sure we have enough police in hand, to protect the situation. And so the court has stated that, all right? Put down little letter C. The local governments may require advance notice and the issuing of a permit. All right, once again, that permit's not really supposed to be to stop you from protesting. It's mainly to make sure that it's all done in a safe manner, that there's plenty of police on hand at the time, and it's not going to cause a war or something like that. Little letter D, freedom of speech and assembly do not include anarchy, rebellion, or revolution. All right, and so you can peaceably assemble, you can peaceably protest, but once again, we can't start anarchy, we can't try to organize a rebellion or anything like that, right? All right, big letter B. This is the Second Amendment, and right down next to that, the right to keep and bear arms. And of course, this is a very important amendment as well. Underneath this number 1, the founders felt that militias are necessary for the security of a free state. The founders felt that militias are necessary for the security of a free state. And by the way, they defined militias as the armed citizenry, not professional soldiers. All right, the National Guard is not our militia. The National Guard is our state army in a sense. All right, Hamilton in Federalist 29 stated, quoted this, the people at large, all right, make up the militia. And the idea being that really the Second Amendment wasn't about personal protection or your ability to be able to hunt animals, as some people have said, but really it was about protecting ourselves from the government itself, from either an invading government or our own government if it became tyrannical. And we mentioned number 2, the founders stated that the right to keep and bear arms cannot be infringed. All right, you can't stop people from bearing arms. All right, and in fact, we see some of this kind of interesting things in Virginia. Colonists were not even allowed to travel unless they bore arms. Jamestown required all citizens to bring weapons to church. They found that sometimes the Indians would attack while they were at church, and so they want to make sure that they were protected. Massachusetts required that all freemen and indentured servants be required to bear arms, and if you did not have arms when you were out and about, they could actually fine you for it. And so we almost see the opposite today, where today they're trying to stop us from bearing arms, and yet back then they almost required you to bear arms. All right, a couple of quotes here. Thomas Jefferson said this: "No freeman shall be debarred from the use of arms." Richard Henry Lee said, "To preserve liberty is essential that the whole body of people always possess arms and be taught alike, especially when young, how to use them." And I think that's a great quote there. We ought to know how to use arms. Alexander Hamilton said this: "That army can never be formidable to the liberties of a people while there is a large body of citizens who stand ready to defend their right and those of their fellow citizens." And so Alexander Hamilton pretty much laid it out there. There can't be a government from outside or even a tyrannical government from the inside that can take over as long as we have a well-armed citizenry. Today, our standing army is about 900,000 troops, but our population is about 350 million people. And so, of course, a well-armed citizenry could stop even our own military, if the government became tyrannical and tried to enslave the entire population. And that's really what the Second Amendment was all about. We put down number 3. Many gun laws were passed in the 30s and the 60s to curb violence brought on by gangs. And then to write this down, in 1993, the Brady laws were passed, which restrict the sale of handguns and require a waiting period. And I think it's a 10-day waiting period, but you want to know about the Brady laws. Of course, Brady was a Secret Service agent that was protecting Ronald Reagan. Ronald Reagan was shot by Mr. Hinckley, and Brady, trying to protect the president, was also shot, and I believe he was shot in the back. It sustained some spinal injuries and was paralyzed. And as a result of that, Congress passed some gun laws that basically, kind of limit the ability to be able to buy a handgun. I gave this quote. I like this quote. "The answer to crime is not gun control, but people control." And really, it's not even so much people control as much as controlling evil in the country. All right? It's not the gun's fault that things happen. It's the people behind the gun. And by taking away guns from good citizens doesn't stop bad citizens from getting guns. And that's the problem that we've been facing. Ecclesiastes 8:11 says this: "Because sentence against the evil work is not executed speedily, therefore the heart of the sons of men is fully set in them to do evil. And part of our problem today in this country is that we are not punishing evil in a speedy manner. Sometimes people wait 20, 30 years before even their punishments are carried out. And that really doesn't do well to stop evil. And so we definitely need a little bit better justice system in regards to that. All right? Big letter C, Amendment number 3, no quartering of soldiers in private houses. And of course, we mentioned that when the British government was in control of the colonies, they would quarter their soldiers in the houses, especially when they thought that areas were being a little bit rebellious. They would put a soldier, let them live in the home. They could eat your food. They could sit in your comfy chair, and they basically took over your house. And by the way, they also spied on you to make sure that you weren't doing anything the government didn't want you to do. And of course, the founders said, we do not want that kind of stuff in there. All right, but put down underneath this number 1, this amendment affirms property rights of citizens. And maybe you haven't thought about that, but the fact that we have property rights is a result of amendment number 3. And then write down number 2, that property rights were considered one of the most sacred rights. The idea that we can have property, a very important thing to the founders. All right, big letter D, amendment number 4. And right next to this deals with searches and seizures. All right, and underneath this, number 1, this protects citizens from unlawful searches without a warrant. And of course, maybe you've watched some police shows where the police officer says, I need to get a warrant to be able to search the property. All right, what's a warrant is given by a judge. The police must have probable cause to be able to get that warrant. They must have a good reason, and that warrant needs to specify exactly where is to be searched, what's the address, what's the room, what are they looking for, and the reasons why they believe there's something illegal going on. And by the way, the police officer has to testify to that under oath in order to get a warrant. And so getting a warrant is a pretty big, important thing. All right. In fact, that's number 2 there. Police officers under oath must give the judge the reason the search is necessary. All right. And so judges don't just give out warrants for any reason. They do have to have probable cause for that. All right. Letter E, big letter E, amendment number 5, criminal proceedings. And of course, when we think about amendment number 5, probably what comes to your mind right away is I plead the 5th. Of course, people that are in court cases, they don't want to testify against themselves. And that is part of amendment number 5, but there actually is quite a bit to amendment number 5. And in class, we read all of these amendments when we went through it. I would challenge you to read amendment number 5 as well. But underneath this, number 1, amendment number 5 deals with this. Number 1, a private citizen cannot be tried for a capital crime or felony without a grand jury considering the evidence. A private citizen cannot be tried for a capital crime or felony without a grand jury considering the evidence. All right. And of course, we mentioned the grand jury is a group of people that look at the evidence before trial and say there's enough evidence to actually try this person. All right. And so amendment number 5 gives that guarantee. Number 2, underneath this, the U.S. Armed Forces are tried in special military courts, and we call those courts court-martials. And of course, the military has their own set of laws, own set of punishments, which are more severe than our own courts of law have. All right, servicemen, by the way, can appeal to the U.S. Court of Appeals, and they could appeal actually all the way to the Supreme Court. However, that usually is handled at the U.S. Court of Military Appeals. All right, number 3, underneath amendment number 5, number 3, a person found innocent of a crime cannot be tried twice for the same crime. All right, now let me explain. There are some instances where it does appear that they're being tried twice, but if the jury doesn't come to a verdict, all right, they fail to reach a verdict, they can have another trial, all right, to try to get a jury that comes to verdict, all right? So that is a possibility. If new evidence comes to light, they can be tried again based on the new evidence, all right? If maybe DNA evidence comes to prove that they actually committed the murder, whatever, another trial can be had, all right? A person guilty of violating both federal law and state law can be tried both in federal court and state court, all right? And so that would be another instance in which they would be tried twice, but once again, that's in federal court and state court. And then we mentioned, of course, sometimes a person is tried criminally as well as civilly. And so those are different instances. What this amendment, though, is saying is, the prosecutor can't try to prosecute the person, fail in the court case and say, well, I'm going to go at him again. I'm going to just try a different technique and see if I can get him convicted this time. All right, we can't keep trying to convict the person without a good reason why we need to go back to court, all right? Under this number 4, under amendment number 5, is a person cannot be compelled to testify against himself in court. And that's, of course, what we think about when we think about amendment number 5. But what you do need to know about that specific point is this is called the Due Process Clause. And you've probably heard that sometimes, maybe even in the maybe police shows or whatever. The Due Process Clause, all right, does not allow a person does not have to testify against himself in court, all right? And by the way, I believe this is true. I believe a spouse is not obligated to testify against her own husband or his own wife as well. A lawyer, of course, a defense lawyer can't be called on as a witness because he's obviously their lawyer. So the Due Process Clause covers a little bit of that. And then on number 5, underneath this as well, this amendment also gives the government the right of eminent domain. And eminent domain is where the government can buy private property at a fair price for public use. Now, I would say that a little tongue-in-cheek. There are plenty of people that disagree with that idea there is found in this amendment. Some people would say that's not exactly what the founders meant. But currently, the way the law stands anyway is the government, if they need property for a certain important reason, they are allowed to take your property as long as they pay you a fair market value. Now, it's supposed to be for necessary public use. I think about a good example of that when the national highways were established, like Highway 80. The government took property using eminent domain because they needed to be able to build a highway across the country. And there were some people that didn't want to sell their farms or whatever, and the government took that property by eminent domain. And of course, the reason for the interstate highways, by the way, wasn't really for our own convenience, although that was a very good side benefit. It was really so that we could transport military equipment from coast to coast. Because we had little roads before that. We couldn't get tanks to be able to go through those little roads. And so we needed to be able to transport our military equipment very quickly across the country. And so that is why the government used eminent domain in that case. However, we do see that today, sometimes the government has misused this idea of eminent domain. In some cases, they'll say, well, we don't think a church is really important to public use, so we want to put a mall where that church is. And sometimes they've used eminent domain in improper ways. And of course, that is not right. All right, that is kind of a little hodgepodge, really everything, all the meat to what we covered. And so hopefully this will be a blessing and a help to you. And we'll be looking forward to seeing you in a couple of weeks. Of course, have a happy Thanksgiving. I am so thankful to be able to be a part of your guys' class. I'm already starting to be sad a little bit in that our class is almost coming to an end. And I've really enjoyed this semester. God bless you. Praying for you.